You are live. The floor is yours.
Good morning, and thank you for joining us today for this special hearing of a challenge. We will start the meeting at 10:02 a.m. But before we start, I would like to ask board and staff to please mute your phones if you're not, or your devices if you're not speaking. And in addition to that, may I have approval of the agenda? A motion to approve the agenda.
So moved.
Okay, so moved and seconded by Bob Harton, Kevin Evans. Any discussion? All in favor say aye.
Aye.
Aye. Seeing all hands. Thank you. The agenda is approved. Next, we will have citizen comments. So at this time, if there are any comments, I do ask that each person speak for 3 minutes total. So do you all know, staff, if we have any comments from the public?
We did have an individual that requested to speak. Miss Ingrid Landis Davis is one of the speakers.
Okay. Thank you, Director Kidd. Ms. Landis Davis, the floor is yours. Can you hear us?
I think she's, it's lit up. I believe she was trying to unmute her mic. Ms. Landis Davis, are you present?
I'm trying to unmute my mic and my camera.
We can't hear you though.
Okay, so I'll speak then if my camera unmutes fine. Today we have with us Attorney Ryan Williams, who is the person that is being challenged. I don't know if he wants to take my spot and speak. We also have Attorney Matt Weiss with us from the Democratic Party of Georgia. If either one of them wants to speak on this issue and this challenge, I'll yield the floor. I'll yield my minutes.
So they will have the opportunity to speak during the challenge.
Mr. Williams will.
Mr. Ryan Williams. Now if Matt Weiss,
I'm sorry, this is Matt Weiss. I'm happy to speak whenever the appropriate time in the meeting is, whether it's now or later.
Mr. Weiss should address now, and Mr. Williams will have his turn as part of the hearing itself.
Okay, then I'll go ahead. Yeah, as Ingrid mentioned, my name is Matt Weiss. I'm the Deputy General Counsel for the Democratic Party of Georgia. I'm not representing Mr. Williams, but I do. Obviously it's a Democratic candidate, so we are interested in the proceedings. Our position is that the appointment was valid. I think under the relevant statute that deals with vacancies and withdrawals, OCGA 21-134. I think it's a little ambiguous, but I think that subsection C, which deals with the ability of like a party to appoint to fill a vacancy, would apply here because the vacancy wasn't, or the nominee, who was the magistrate judge, or the candidate for the magistrate who withdrew, was the nominee by virtue of being the only candidate in the race and not by means of the primary, which is why there's language relating to that in the statute. I think here, there really is. It's not, the statute doesn't contemplate this exact situation. There's something that prohibits the appointment of an individual in the event of a death, withdrawal, or disqualification in between the qualifying and the nomination. But there's no specific. We think it falls under subsection C because they are the person who was disqualified was the nominee by virtue of being the only Democratic candidate in the race. But even if the board was to take the position that statute subsection did not apply, there really is nothing in the statute that prohibits the county party from filling the vacancy during this time. It's not explicitly addressed. And we think that it wouldn't make sense for the legislature to have addressed all these other situations, to have left a basically a hole in the statute for, there's a specific basis for replacing a candidate during qualification and then after nominations, and it doesn't. There's really no logical reason why they would exclude it in the kind of interim period, and that's why we think subsection C.
We have approached the 3-minute time frame.
Okay, thank you very much.
Thank you. Any more citizen comments?
Mr. Unvala, do you have any more individuals that requested to speak?
Outside of Scott Camp.
Okay.
Mr. Camp will have his time frame as part of the hearing itself to address the board.
So next we have the motion to hear the challenge of Elector Scott K. Camp to the qualification of Ryan C. Williams to seek and hold the office of Chief Magistrate Judge of Douglas County. So how it will go today is that Attorney Camp will have 15 minutes. Then Ryan Williams will have 15 minutes. And then if there is rebuttal, you each will get 2 minutes total. From that point on, after we've heard, we would then take a motion to determine if this case will move forward or if it's dismissed or sustained. So first we will have Scott K. Camp up. Attorney Camp, are you ready?
Hear me?
Yes, we hear you.
I just realized I didn't have my jacket on.
That's okay.
As a preliminary matter, a couple of quick things. I had sent an email just recently.
We do acknowledge receipt of items, what you have labeled as items 3 through 7 to accompany the initial motion. We have prepared that packet and transmitted those files to all of the board members. Those files are also available on the county's website with your initial motion and what you presented as exhibits 3 through 7 as well, to which your legal assistant dropped off to a physical copy to the office at 9:46 on this morning.
Okay, I had emailed those to your office yesterday.
We were in possession of those, and we have transmitted those to the board.
Okay, good. I did that as an accommodation, thinking that would make it easier for your office to forward it to the board members. But I never received confirmation you received it, so I had my secretary come up and just file the hard copies as well. Also, so 3 through 7 are part of the record. Is that correct?
Yes.
And my original request for a challenge, that also is part of the record.
Yes.
And there were 2 exhibits, 1 and 2 were attached to that, and they're also a part of the record, correct?
The entire initial exhibit is counted as one that was transmitted its entirety.
Okay, thank you. Also filed this morning a brief, and I guess I'm sure that's part of the record as well.
You filed a brief how this morning?
Well, my secretary filed it this morning with exhibits 3 through 7.
There was an issue. We were unaware of. Well, we have the entire exhibit, but it did denote that there was a separate brief attached to that. But that entire motion that you emailed to our board has been sent. So the entire file that you transmitted to the office as a physical copy this morning will be part of the record and will be transmitted to any of the appropriate state or federal agencies that proceed after this hearing.
So, but again, just to be sure, the brief is also a part of the record?
The entire...
Yes or no, please.
The entire piece that you transmitted to the office has been transmitted.
You're still not answering my question. Is my brief a part of the record?
The entire submission that you transmitted to the office has been transmitted. The brief, if you review the county's website, if the brief is part of that submission, I can attest to what you actually
I'm in the middle of this hearing right now. I can only operate one computer at a time. I'm not a super genius on computers. Will you just tell me, are you including my brief in the record or not?
Yes,
That's
everything that you transmitted.
So what we've heard thus far is that everything you submitted is on our website. So if you want to take the opportunity to go to the website and check yourself, please do so. However, your time is reducing, so you have until 10:24 a.m. to make your case.
So I can't check. I don't have time to check that. And you won't confirm that my brief is part of the record. Just Malcolm's taken up half my time so far. So I'm
My
going to
name
ask
is not
Malcolm not to
Malcolm, and
talk.
I can attest to what you gave us.
So that's Director Kidd that you're speaking to now, Attorney Camp.
So I also delivered as well just a few minutes earlier an email, and I also had it hand delivered to your office just a little earlier, stating the issues that I'm proceeding on. I'm not proceeding on all of the original issues that we filed a challenge on. And so since you've received that, and you say everything you've received is a part of the record, then I'm assuming you're going to include that in the record as well. So let me just say, as far as being my challenge, reading the statute, I'm not so sure I have the right to make a challenge. The deadline for electors to make challenge expired March 29 of this year by statute. But the board does have the right to make a challenge at any time up to the time of the election. So I really think it's a hearing on the board's part for the challenge. But either way you want to call it or consider it, the provisions of the election code that are applicable here start with section 21-2-150 and go through, I believe it's 158. Political parties are required under the code to determine their nominees for election by primary. Period. You don't get to select your nominee. You determine your nominee by primary. The time for primaries are defined by statute. And without going through the statutory formula, the time for a primary this year was March 7 through March 11. Mr. Williams did not qualify for this particular position. I understand he qualified for Superior Court, and I understand he says he's withdrawn from that. But he did not purportedly qualify for this position of Chief Magistrate Judge until April 29, 7 full weeks after qualifying ended. And you just don't get to do that. There's no provision in the law that allows someone to qualify even one day after the end of qualifying period, much less 7 weeks or any other time period. There are two very limited exceptions during the primary season whereby someone who did not qualify during the qualifying week may still be allowed to qualify, and that is if after qualifying week but before the primary a candidate dies, or during the same time period after qualifying week but before the primary the incumbent who's running for re-election withdraws. Neither one of those situations have happened, so there's no right to reopen qualifying for the Democrat primary. And even if we were in one of those situations, the Democrat Party does not, or neither party is allowed to simply select who they want their candidate to be in the primary. No, you have to reopen qualifying for at least one day and no more than 3. That's in the code. And I'm not citing the statutory provisions because they're all cited in my brief. If the elections office would be good enough to forward that to board members for consideration, that'd be good. There you go, interrupting me again, Mr. Kidd.
I'll add your time back, but since this is a public hearing that the public is not present to your brief, if you could cite the code sections that you are asking the board to consider as part of this hearing, we will add your time back.
No, I'll let my brief speak for itself. And these provisions are all in OCGA section 21-2-150 through 158. And look, there's just no provision in law whereby someone is allowed to change their mind. They did, at qualifying week, Mr. Williams did not want to run for Chief Magistrate Judge. He chose not to run for Chief Magistrate Judge. Did not qualify during qualifying week, and he doesn't get to change his mind later. And as far as section 21-2-134 goes, the entire code section does allow for a substitute nominee to be named by a political party under certain defined limited circumstances. Not every provision reads exactly the same, but basically if a candidate, no, well, it would be a candidate, but if a nominee dies, withdraws, or is disqualified after the primary, then section 1, or part 134 may very well come into play. Subsection C cited, and I'm sorry, sir, I should have written your name down and I didn't, but cited by the previous attorney. Any vacancy occurring in a body nomination, we don't have that situation. That's not applicable. Or political nomination. Well, we do have political parties involved, but there is no political nomination. But see, you cannot have a substitute nominee until you have a nominee. And remember, the political party gets their nominee by primary. Has to be voted on, and you have to win the primary. You don't have to like that, but it is the law. So if you don't have a nominee coming out of the primary, 134 is just not applicable. And if it ever does become applicable, it becomes applicable after the primary, when there has been a nominee. We don't have any nominees for any of these races yet. Those will be determined May 24th, the election. But at any rate, frankly, even if 134 were applicable, it's not. But even if it were, the procedures whereby a political party can name a substitute nominee are very explicit, and you have to follow them right to the letter. And the Democrat Party did not do that in a number of ways. I think maybe the easiest way to cite that is that the right to nominate a substitute or name a substitute nominee actually belongs to the state party, not the local county party. The state party has to make that nomination, and they can delegate it to another committee, but it's the state executive committee who has that responsibility. That hadn't been done in this particular situation. The notice of a substitute nominee has to be signed off on by both the secretary and the chairman of the committee. That's never been done. It's not the Wild West. You can't go whipping down the street, firing your guns off, doing whatever you want, whenever you choose to. And that's, frankly, that's the behavior we've had throughout this election season. But the code doesn't allow it. And I would strongly encourage the board to follow the law this time, and to disqualify this candidate. Don't have anything against Mr. Williams. I've never met him. I'm sure he's a great person, but he just didn't qualify during qualifying week, and neither of the exceptions apply that would allow him to qualify at this time. I had notified the board prior to the hearing that other issues I'd raised originally in my request for a challenge, I've withdrawn those requests at this time because they're issues that you really need to be able, or at least I felt like I needed to be able to have the ability to subpoena witnesses and documents and other evidence to truly make out my case. And I don't have that authority with this board. I don't have the ability to have a subpoena issued by the board. So I decided to withdraw those at this time. So I'm proceeding basically on You know, the argument I've made that Mr. Williams is not properly qualified, he's not timely qualified, and he should be disqualified from the race. That's all. That's all.
Okay, thank you, Attorney Camp. Next, we'll hear from Ryan Williams, 15 minutes. And then after that, Director Key, can you give us an update
Yes,
on?
I would like to give a brief synopsis on the officer's position.
Yes. All right, Mr. Williams, are you available? Okay.
I am. Can you guys hear me? Okay?
Yes.
Good morning, board. You know, I obviously accepted this nomination, and now I'm dealing with this challenge for my qualifications based upon the OCGA 21-2, 150 through 158. I did not get a copy of the alleged brief that was filed this morning. As a challenger, I should have been privy to it, but I did not receive that. However, I am understanding that the challenger did withdraw, I guess, the latter part of his challenge, and is only proceeding on the part of the qualifications based upon the party's ability to nominate a particular nominee, and in the primary race. That being said, I do believe that the controlling statute that is applicable in this matter comes from 21-2-150 through 158, which refers you back to 21-2-134. And based upon the plain language of that statute, the Democratic Party has the right to nominate a candidate to replace a deceased or disqualified candidate, as long as it is done by 4 p.m. the next business day after the disqualification, the withdrawal, or the death of the prior candidate. The statute anticipates the placement of the new candidate on the general election ballot. The issue before the board is the timeliness of my nomination, the time that I qualified to be placed on the ballot. And I will address that by saying I formally withdrew from the Superior Court race on April 26th. At the same date, the Democratic Party nominated me to become the Democratic candidate for Chief Magistrate Judge. The previous candidate was disqualified the same day. So the issue, I guess, is the process of the qualification. The basic qualifications for the position of Chief Magistrate Judge, I exceed those undoubtedly, and that was not brought up as in question. I obviously resided in Douglas County since 2018. I'm 35 years old, and I hold a law degree. I practiced as a criminal defense attorney and a previous prosecutor since 2013. So to say that I qualify for the position generally is unquestioned. To say that I qualify for the position based upon the ability of (21-2-134), and I will point the board to the portion of 134 that says no vacancy on the ballot for a general election or for a nonpartisan election shall be filled except by reason of the death or disqualification of a candidate or the withdrawal of a candidate as provided by in paragraph 2 of the subsection. Paragraph 2 of subsection C actually states that in the case of a public, specifically states that in the case of a public office where the candidate must qualify on the county level, which is what we have here, a subcommittee thereof, which is the Douglasville Democratic Party, has the ability to then determine on its own whether to fill the vacancy, but is authorized, though not required, to seek the recommendation. And that decision had to be made to whether to fill such vacancy by the state committee by 4 p.m. on the next day following the actual knowledge of death or disqualification of the candidate. What the challenger, Mr. Scott, mentioned was the ability of Douglas County Democrats to actually appoint me or nominate me, and that is covered by the Democratic Party of the state of Georgia's bylaws, in which they refer back or allow for the local party to appoint or to make these decisions as it relates to their local elections. That being said, the Democratic Party of Douglas County did make the decision to nominate me for this position. They've done so within a time frame, which you have not heard that it was outside the time frame. They've done so within the purview of what was allowed within 21-2-134, and they made a decision. And I think that decision should stand. I don't want to rehash the specifics of 134, but what I can say is that there was a disqualification that was brought by, I also think the same challenger, in which disqualified the application left a vacancy, which also will leave a vacancy on the general election ballot. And because there would be a vacancy on the general election ballot, the party has the power to fill that vacancy. 134 does anticipate this occurring during the general election and not as much as in the primary election. But there's a twofold that should be addressed here. One, going back to 21-2-134, C said occurring in anybody nomination or party nomination filled by means other than by primary, by reason of the withdrawal, death, or disqualification of a candidate after nomination, may be filled by substitute nomination made by committee as authorized by the rules and regulations of the party, or body to make nomination in the event of vacancy on the party and body ticket. And also, more importantly, as we know, 150 through 158 is the controlling law here. It refers us back to the 134. In the event of a withdrawal, death, or disqualification, I think the challenger would be most benefited if he would have raised his challenge that there should have been a special primary held, which shall allow for the party to then fill that particular seat. Because obviously we know there was a disqualification that occurred. So that being said, I feel as though my qualification was timely. It was properly done. I had followed the letter of the law. I removed myself from the Superior Court race, entered this race by nomination. They nominated me within the time period allotted for, and I accepted that nomination, paid the required fees. Nothing else.
Thank you, Attorney Williams. Director Kia, do you want to give an update of what has happened since the nomination and when Attorney Williams qualified for this particular race?
Yes, ma'am. The office does feel that the relevant code sections that are applicable to this case were previously stated. Give me 1 second. In this particular case, a judicial order was issued on the 26th of April disqualifying the previous party nominee on the Democratic ballot for the magistrate court. That vacancy at that point allowed 21-2, that disqualification of a candidate allowed 21-2-134 subsection C to begin. At that point, it has specific language that allows the state party or a subsidiary of the state party to issue a substitute nomination of a candidate. In this particular case, on the 26th, the judicial order disqualifying the previous candidate was issued. On the 26th, the Democratic Party did issue its rendering of the substitute nomination. The Douglas County Democratic Party is a qualified subsidiary of the Democratic Party of the state of Georgia. The candidate in question on the 26th did issue a letter of withdrawal from the previous race for Superior Court. There is no superseding statute with a time frame for withdrawal. In this particular case, once the political party issued its recommendation for a substitute nomination, to which the parties are responsible for qualifying candidates to represent their political party. They did transmit that to the elections office. The elections office at that time did convene a special hearing that was convened on the 29th of April, at which time the Board of Elections and Registration did accept the substitute nomination offered by the Democratic Party, with the caveat that the individual in question fill out the required paperwork and pay the required fees. On the 29th of April, the individual in question, Mr. Ryan Williams, did come into the office and fill out the required paperwork and transmitted the required payments to which the office has documented. We feel that in this particular case, 21-2-134 subsection C is applicable in this particular case, and all of the provisions outlined in this code section were applied and were actually transmitted in a timely fashion to the office.
Thank you for that feedback. Any questions from the board at this time? Okay. Hearing none, do we have a motion at this time on what we heard today?
Madam Chair, this is Maurice Hurry. I make a motion that we dismiss the challenge from Mr. Kemp based on the information provided today.
Okay, is there a second? Properly seconded. Any discussion? All in favor say, okay, Bob Proctor.
I couldn't get unmuted before in time. And I haven't had time to understand or review Director Kidd's comments there that he just made. So the references to all of these code sections, I don't have them all memorized. So my comment is, can the state party rules supersede this Georgia election code annotated?
No.
Mr. Kemp, that is not being addressed to you. Please allow questions being addressed to the board, or the board address it to a member of the board or to our legal counsel, please.
I did want to make a brief rebuttal if at some point, if I could. I promise it would be brief.
I'm happy to weigh in too.
Can we do one thing first? So one, let's answer Bob's question. I don't know if Attorney Watson or Director Kidd wants to do that, and then I will give it to Camp.
I'll go, and then Attorney Watson. We do not believe that we're applying no party rules or statutes to this interpretation. This is the code section that allows the political party in this particular case to make a substitute nomination. I'll let Attorney Watson speak for himself, but I believe the code is clear with their ability to do this substitute nomination.
But it has to be done by the state party, is that correct?
No, the code section actually reads as follows. In the case of
I'm sorry to interrupt, but where are you? What page number?
I'm going to give you the code section on page 117, code section 21-2-134, subsection C, on page 117 of the annotated code book.
Okay.
It begins as follows. It says, in the case of public office for which a candidate must qualify with the county executive committee, the nomination may remain vacant or may be filled at the decision of the state executive committee of the party. The state executive committee or a subcommittee thereof may determine of its own whether to fill a vacancy, but is authorized, though not required, to seek the recommendation of any of the following persons for the purpose of determining whether to fill a vacancy. In this particular case, the state executive committee has submitted documentation in February of this year to which the original challenger has part of his motion the letter authorizing the county Democratic Party to act on behalf of the state executive committee. The attorney for the state executive committee is on to attest to the fact that the county party is an authorized subsidiary of the state party.
Okay, I will listen. Yeah, in the rules there were 2-minute rebuttals allowed.
Correct. So Bob, did that answer your question?
Somewhat. if you will. I don't recall seeing anything from the state party out delegating their authority to the local party, Democratic Party.
We have, as part of the political parties are required to submit at the beginning of the year their list of officers of the party, current bylaws, and things that are such authorizing them to be a political party. We have the documentation within the office, and after this meeting, I can transmit to the board the letter authorizing the county's Democratic Party that was issued, I believe, the 12th of February to the elections board. This is also information that was presented by the challenger in this case that he obtained through an open records request to this office.
Okay, but after this meeting, it won't be of any value because we're going to take action now, as I understand it.
As the Director of Elections and Registration, I can attest to the fact that this letter is in the possession of the elections office. That's what I can give you now.
Okay.
Okay.
All right. I yield.
Thank you. Attorney Cam, you had a 2-minute rebuttal.
Well, I think that someone had asked Mr. Watson to weigh in, and he was going to go before me. That's what Milton
I don't
said.
think hard to add. Director Kidd has handled it perfectly.
Thank you, Attorney Watson. Attorney Cam, do you have a 2-minute rebuttal?
I don't know if it'll be that long. If you read 21-2-134C, I mean it's these code provisions sometimes are kind of hard to wade through because they're legal terms of art, and you have to pay attention to the definitions contained in 21-2-2 on a lot of these terms and phrases. But a nominee is a person who's chosen as a primary to be a political party's candidate. 134C, vacancy of a party nomination under the stated circumstances. Death, withdrawal, disqualification. The code says after nomination. Then you can go to a substitute candidate. You cannot go to a substitute candidate before a primary. That's just the plain language of this particular code section. And I would also point out section 21-2-151 says that a party's candidate shall be nominated at the primary. It means election. It doesn't mean some committee decides this is going to be our nominee or this is going to be our candidate. And again, 153 requires that a person who wants to run for a party's nomination has to qualify during the qualifying week. And there's several procedures set out in that for how that's done. I think the law is clear. As far as the state board give a blanket authority, purportedly, to a local, not state board, a state executive committee giving a blanket authority to a county executive committee party.
That's your time. Thank you.
Well, now hang on a second. Somebody mentioned there being rules. I haven't seen any rules setting forth that I have a limited period of time to speak. And I asked for the rules. I asked if there were any rules in the open records request. And the response did not include any rules that contained any of these time limits.
The rules were set for this
meeting. My 15 minutes were not used up before.
The rules were set before this meeting, and you did not have any, you did not say anything at the beginning. Attorney Williams, do you have a 2-minute rebuttal?
I do not. I think everything has been addressed already.
Okay, thank you. So there is a motion on the floor. So at this time, are there any additional questions? Okay, hearing none. The motion on the floor is, there is a motion to dismiss this case of the challenge that came before us from South K Camp. All in favor, say aye.
Aye.
Aye. I see 3. And all against, say nay.
Nay.
I hear Bob and Michelle. So 3, 4, and 2 against. So this case is dismissed. And Attorney Williams will remain on the ballot in the general election, Director Kidd? For primary and general.
The way it works is when a candidate is the only candidate on the ballot, we essentially, that candidate is deemed to have voted for themselves for this election. So with the acceptance of the nomination, we're essentially calling that particular race for this primary ballot, and that name is subsequently forwarded to the November ballot. In this particular case, as with all others, the whole point of the Board of Elections and Registration is to essentially interpret the code section and to apply it in the most efficient and effective manner possible to be able to facilitate the elections process.
Understood, thank you. Are there any board member concerns at this time? Okay, hearing none. Our next regular board meeting is Thursday, June 9th at 5:00 p.m. It will be virtual, so we hope to see you then. Other than that, have a wonderful day, and thank you all for tuning in.